Well, thank you everybody for joining us today. We have a really fun conversation ahead of us. I was recently introduced to Jennifer Osgood with BCR Law Partners, and what we're going to focus on today is business conflict resolution. And with a little bit of e-discovery, but really we want the educational aspects to be around how Jen and her team put together some really neat principles around business conflict resolution in their practice. So, Jen, before I get too carried away here, why don't you tell us about yourself and BCR Law Partners?
Perfect. Thanks, Rick. So as Rick indicated, my name's Jennifer Osgood. I'm a law partner here at BCR Law Partners. And as Rick already alluded, BCR stands for Business Conflict Resolution. So what we do is in our name. A little bit about me. I am a Texas born but Northeast raised individual, and came out to Colorado after graduating law school with my husband. And Colorado has been home ever since. I have spent the entirety of my practice practicing in Colorado since graduating law school at a date which I won't disclose because it's been long enough that I no longer need to. I started out my legal career as primarily a transactional lawyer doing some securities work. And quickly figured out that I was not a transactional lawyer, that I needed something a little bit more to pique my interest, and ended up switching over to litigation. And I've been a litigator for the last 20 plus years. So that's my life and career in a nutshell. BCR Law Partners has actually been around for quite some time. It was formed in 2019, or 2009. So I think we're going on more than 16 years now. I joined the practice in 2019. And BCR Law Partners, it's a new name, but same firm. The firm was formerly Chipman Glasser LLC. And we recently went through a rebrand at the start of this year when I became an equity partner in the firm.
Awesome, cool. Well, let's dive into the business conflict resolution. So, for those that are listening and watching that aren't familiar with it, let's give like sort of an overview, and then who are your clients typically, and what are the challenges that you're trying to solve with them?
Sure. And maybe let me just start with who our typical clients are. So typically we're working with business owners, we're working with entrepreneurs, and that can take a variety of forms. So sometimes that may be members or managers in a limited liability company. It could be shareholders or directors and officers in a corporation. So really anyone within the company, and sometimes the company itself, that is in a executive position, decision maker, that type of individual. We often deal also with small to mid-sized companies. So we're dealing with a lot of closely held companies. And what I mean by that is, under 10 members. We deal a lot with family-owned companies, whether that's husband and wife, which that can be super tricky.
Yep.
I could not work with my spouse, so I admire those who can. Or whether it's like a father-son relationship. So we deal with a lot of those individuals. But like I said, really anyone who is in a position within an organization that has decision-making authority. Challenges? Was that the second part of the question?
Yeah. Like what sort of challenges? So now, I mean, I'm kind of picturing just by hearing those types of clients that you have. I can always surmise, but what are some of those? What challenges that you're solving with them?
Well, I bet you can guess for the husband and wife owned businesses what some of those challenges may be. So we do what we call business divorce. And the reality is, even when the owners of the company aren't married, business conflicts and business disputes amongst owners really do resemble a divorce. While it's business and it should be pure economics, and that should be the primary driving, motivating factor on how to handle things, there is often a lot of personality and emotion that we're having to manage behind the scenes in order to effectively resolve disputes. So the types of cases that we're typically dealing with, so we deal a lot with a membership dispute. So let's say you have a 50-50 ownership in a company and they've reached an impasse. They can't agree any longer how to manage their company and where they want to take the company. And when they joined and formed their company, they were the best of friends. They were each other's emergency contacts, and something happened along the way. And the documents that they use to form the company don't provide an easy exit strategy. Sometimes it's a little more complicated than that. You'll have maybe a member who is taking funds from the company or locks one of the other members out of the bank accounts of the company, or is using trade secrets or something like that. So we handle a lot of those types of disputes, and those can really occur either in the limited liability context or the corporation context as well. So another type of litigation that we often see ourselves involved in, and we really do this on both sides, uh, representing the companies and then the investors or owners of the companies as well. So we do a lot of shareholder derivative suits, like I said, on both sides of the equation. And that's a scenario where you have the investors of the company who are asserting claims typically against either the owners or the managers or the directors of the company on really on behalf of the company. And maybe that's because, you know, there's mismanagement or breach of fiduciary duty or something like that. The other thing that I wanted to just briefly touch upon is probably the third area or type of case that we typically see the most of is post-transactional disputes. So we certainly do some what I would call transactional light work. Both Dan, my partner Dan Glasser, and I both have some light transactional background, and we can do that work. But we're not the ones typically putting the deals together. We do get involved when those deals go south. So let's say you sold your business, you entered into an asset purchase agreement, and as is almost always the case, part of the purchase price is financed, and you're a year into having sold your business, and now the new buyer or the new owner of the company suddenly stops paying you. It happens all the time. I tell people, get what you get at closing, and anything you get after that is great. But you know, we see this scenario all the time. Or conversely, you know, sometimes we represent the buyer of the company who a year into running the company is like, this is not what I thought I was buying. They didn't tell me X, Y, and Z, and that's really materially impacting the terms of the deal that I thought we had made. So those, in a nutshell, are really the types of cases that we see the most often.
So it sounds like a lot of this is after the fact, sort of like litigating things that have gone south. Are there preventative, or are there things you do on the front end to create really good agreements? Or, you know, what are some of the elements to help prevent some of those downstream, you know, potential chaotic or challenging, you know, pieces of litigation or whatever?
Right. So typically, we're not getting involved until there is some kind of dispute. That does not necessarily mean litigation. And frankly, one of the best things that you can do to avoid ultimately ending up in litigation is identifying the issue before it becomes something bigger than it needs to be, right? So before conflict between two members rises to the level of one locking the other out of the business or doing something that's going to be a bigger impetus and a faster path to litigation. So really where we like to get involved is as soon as there is some semblance or an idea of a dispute, or a member in a company or a director in a corporation has identified we have a business problem and we'd like to resolve it before we spend all the time, energy, and money that we know litigation is going to take. And from my experience, the sooner we can get involved, sometimes we have to go in super aggressively, but oftentimes we're going in looking for a resolution, right? So I
Hmm.
think anybody who has been unfortunate enough to have to deal with litigation knows how expensive it is. And if there is a path towards resolving things before they get to that point, that is always one of our primary goals that we have to keep in mind.
Yeah, interesting. Okay, so then that aspect of it, could you distill them down to maybe three main elements or three sort of takeaways for the audience?
Sure. So I think the first thing that at least we strive to do with our clients from the outside or from the outset is to really identify what is the real business problem and not just identify what are the legal issues, right? So our goal is not just to present legal issues or legal claims, but really tailor those claims to what your business objectives are. And oftentimes there's several different ways that we can approach something, but we really can't figure out what that approach is going to be without really understanding what is your business problem, what is the outcome that you want, and how can we help get you there. So I think that would be the first and kind of threshold issue is the company or the individual helping us to identify what is the real business problem as we're crafting a strategy. I think secondarily, as I was alluding to before, figuring out from the outset what are the possible off ramps, right? Where
Mm.
can we and how can we resolve disputes strategically and early so that we can get our clients back to doing what they do best? And that's not normally litigating, right? That's normally running
No.
their business, doing their
Yeah.
day to day. And so from the outside, I think the lawyers at BCR Law Partners, I mean, we really have a mindset to um, early case assessment, really getting our hands around the facts of the case, the legal issues, and creating a strategic plan to formulate how are we going to best resolve that. The goal isn't um, just to litigate every single case, but really to figure out a path forward. So,
Yeah.
from my perspective, not every dispute should be litigated and not every case should settle immediately. Sometimes you do have to do some litigation to put yourself in the best leverage position to ultimately, hopefully, reach a resolution. And I think third, the goal is particularly when we're representing a limited liability company or
Hmm.
a corporation is how are we going to protect the company going forward, right? So how can we both structure the litigation as well as um, what may occur after the litigation to position the company to be in the best position to move forward and move forward in a healthy and productive way, to really help take the lessons that we learned during the litigation process to set the company up for success in the future. So I think those would probably be the three primary um, takeaways.
Yeah, that makes sense. And thank you for that. So maybe switching gears a little bit, being that we're an e-discovery company and you have been a great partner of ours for quite a while, would love to just sort of dive a little bit into how our technology, right? So Cloud9's review, how has that been helpful for managing these types of cases, right? Some probably don't have much data to review, others might have more, but just curious on your take on how the technology has helped your practice.
Sure. I mean, we couldn't do what we do without companies like you. Cloud9 has really helped us facilitate our practice. So my business partner, Dan Glasser, and I, we both came from larger firms, but BCR Law Partners, I mean, we are a small boutique litigation practice, but technology like Cloud9 really helps us compete with the bigger firms. So at this point in time, the world in which we live in is very, very data centric, right? So there are so many means that everybody communicates. Almost all cases are going to be a high volume of data. Um, that varies still pretty greatly from case to case. But when we're looking to integrate, text messages and all the different messaging platforms and all of the emails, and I mean, there is so much data that needs to be brought into cases. We couldn't do what we do without having a solid base to review them, to review things in a really streamlined manner so that the various team members from paralegal to associate attorney to partner level attorney can really efficiently move through a case and manage a case and know what we're looking at. So that's been a really critical part of our practice. And I think for myself and Dan Glasser has been also a critical piece in it makes us competitive, right? So even though we're a relatively small team, we can do the same thing that the 100-person law firm can do because we have the technological support behind us.
That's great. Wow. I appreciate that, and it's good to hear, like that perspective. Now, sort of taking this plane down to the runway here shortly, whether it's on the practice side, like we talked about first, or the tech side, is there one main takeaway or one principle you want to revisit or state as a like, hey, this is the thing I want you guys to hear from this conversation today?
Yeah, and really, it would be, I think almost every business at some point in time is going to have a conflict. That is the nature of what we do. And sometimes it's internal and sometimes it's external. But I think the biggest takeaway would be to react and respond early, identify those disputes early, engage counsel early. It's not our goal unless we need to escalate things. Our goal really is to get involved, to evaluate, to assess the situation, and to help our clients resolve these issues in the most efficient and productive way. And so that would be my primary takeaway.
I like that. I like that. Yeah, well, thank you all for joining us today. And Jen, thank you so much for your time. I really appreciate the prep call. It was really fun. And then certainly this has been a really great conversation today as well. And so thank you.
Thanks so much, Rick.